Hi, everyone. We are still about a minute early, and I'm watching people click in, so we're going to give everyone a couple of minutes. And we always start a tiny bit late just to make sure everybody gets in. All right, respecting everyone's time, let's get started. Thank you for joining us for Victims of Crime and the Civil Justice System in Missouri. My name is Renee Williams. I'm the Chief Executive Officer of the National Center for Victims of Crime. And joining us today, we have two very special hosts who we owe a big thank you to, Reed Martins and Ryan Frazier. And I'm going to go ahead and let them introduce themselves, starting with Reed.
Thank you, Renee, and thank you for having us today. Good afternoon to everyone. My name is Reed Martins, and I'm an attorney located in Kansas City, Missouri. I practice primarily in Missouri and Kansas. I've been with this firm, Monsees and Mayer, my entire practicing career, so about 10 years. First as a clerk and then an associate, and they kept me around. I'm now a shareholder at the firm, and the vast majority of my work will be what we're going to talk about today, representing victims of crime and specifically victims of sexual trauma.
And Ryan, would you like to introduce yourself?
Thanks, Renee. My name is Ryan Frazier. I'm also at the law office of Monsees and Mayer. I've actually known Reed a long time. Unfortunately, we went to college and law school together and now practice and are partners together at Monsees and Mayer and are lucky enough to represent victims and survivors of sexual assault. We were talking about some memorable cases to mention. One case that I'll probably mention throughout this seminar today is I'll call it the Smith case. It's all of our cases in this area are memorable for one reason or another, because these people have been through such horrible times in their life. But this one is most memorable to me right now just because it was recently wrapped up, and I had the privilege of representing a family who the son, who was 12 years old, was sexually abused for multiple years, really, by his pediatrician. So I'll probably talk more about this as we go through it, but there was a lot of grooming involved and some negligent hiring involved by his employer that led to the abuse. So that's on the forefront of my memorable cases right now, just because it just got wrapped up. So it was a privilege to get to represent him and his family.
Thanks, Ryan. All right, before we really get started, a couple of housekeeping items. First of all, it should come as no surprise that we are going to talk about some traumatic things. We'll get into cases. If you need a minute, put us on mute, hop off for a while, take good care of yourselves. Also, to that point, we will be recording this. You will all get a copy of the recording and the slides at the end. There will not be CEUs offered, but we will give you a certificate of attendance. And finally, we are not checking the chat except for when I ask you to type into the chat. So if you have any questions, we're going to take those as they go. So if you have a certain question that's really pressing or about a specific topic that we're talking about right then, please make sure you put it in the Q&A. So we are going to get started, and hopefully we will get everybody out of here maybe a little early, but definitely on time. So just a little bit about the National Center for Victims of Crime. Most of you know it because most of you found out about this webinar through our listserv. We are a nonprofit based in Washington, D.C. We focus on best practices when helping crime victims, public policy, and public education, such as this webinar. We do host the National Training Institute every year, and that will be in Orlando this year. And we do hope you'll join us. It's September 3rd through the 5th. And We are actually hosting a super exciting first of its kind inaugural conference for victims of crime who want to become advocates. So stay tuned to your email for more details about that. A little bit about the National Crime Victim Bar Association, which both Reed and Ryan are members of, and they are what put on these types of webinars. We're a professional association of about 400 attorneys nationwide who are dedicated to helping victims seek justice through the civil justice system. We make sure that all of our attorneys are victim-centered and trauma-informed. We offer civil justice seminars like this one, state by state, so we can give everybody an idea of what victims go through when they are in the civil justice system. And we also operate an attorney referral service, which is available on our website. You could fill out the form. Each and every case is reviewed by me, and I do the best I can to review those cases to our attorneys to make sure that victims are getting to the right folks. We'll talk about this a little bit later, but when there is a chance for money and big settlements and things are making the news, you tend to see attorneys kind of come out of the woodwork, and that can really harm victims. And so we want to make sure victims are getting to the right place. So that attorney referral service does that. There will be times that I can't refer a case, and we'll talk about those in a minute. So with that, I'd all like you to use the chat so we kind of know who we're talking to and what we're doing, and so we kind of know how to have this conversation. We want to know, how do you serve victims of crime? What state do you primarily operate in? And do you have any experience within the civil justice system? So if you guys can go ahead and put that in the chat, I'd love to see that chat light up. I'll give you a few minutes. I used to get yelled at because I would jump around too fast and when nobody typed, and my staff would send me a message that were like, give people a chance to talk, geez. Okay, we've got psychology students in Texas. So Texas is going to be a little different. Oh, some are coming in through the Q&A. Good. Prosecution-based victim advocate in Missouri. Awesome. Some experience with crime victims, law enforcement victim specialist. Okay, lots of victim advocates. Any attorneys in the room? Give everybody a chance to say attorneys. Oh, hey, Meg. So Meg Applegate is on, everyone, and we know Meg, and we are very good friends of Meg. Great to see you on. All right. No attorneys. Awesome. I love not having attorneys when we do these. It makes our job a little more fun and a little more easy. So let's get into victims of crime and the justice system. And we're going to focus mostly on the civil justice system, but I like to make sure that we cover the criminal justice system and the family justice system, just so folks know what we're talking about. To address a few misconceptions at the outset, you always hear everybody has a right to an attorney. Not true. Everybody has a right to have an attorney present if you can afford one. In our justice system, there's a case called Gideon versus Wainwright. That is the case that decided that every criminal defendant has a right to an attorney. However, there is no what we call civil Gideon. So if you are a crime victim or any type of individual, you don't necessarily have a right to have an attorney paid for by the government. In some family law cases that involve child removal, the state will step in and provide an attorney for the parents and a guardian ad litem for a child. But again, you have a right to have an attorney present if you can afford them. We also hear a lot, you have a right against self-incrimination. A lot of people love to plead the fifth. That's not a thing unless you're a criminal defendant, or you could be giving testimony that's criminally incriminating against you. So you can't always plead the fifth. And then my favorites are about money. Winning a lawsuit means that you get tons of money at the outset. That is not true, and we're going to talk about why. Going to court is free if you get an attorney that'll act for you. Also not true. And victim expenses are paid by no one. Victim expenses are usually paid for by the victim. So quickly, an overview of kind of all three justice systems and how they play out. Criminal justice system, we're going to get a little more into this. It's a crime against the state. People versus Smith, California, the People versus O.J. Simpson, Ohio versus Reed. And it judges the guilt or innocence of an offender, and it attempts to punish them. But there is no focus on the victim there. The civil justice system's a little bit different. The defendant or the perpetrator is held accountable directly to the victim, and that makes a huge difference. The civil justice system doesn't look to punish people. It's not looking to put people in jail. It's really just looking to, we used to say make victims whole. That's kind of a BS term, but it's looking to help victims in some way. Those cases are usually based in torts or contracts, and we're going to get into that. Family court usually falls under civil court, but we see a lot of cases, and I'm sure you will all know this, where that falls, that implicates crime victims. And so really quickly, because I am not a family law expert, I don't do family law, I've never done family law, and I'm not good at it, but I want to give you guys an idea. So the family court system is going to be anything about divorce, any type of custody, and any alimony payment supports. In most United States, I actually don't know of any state that this is not true. A marriage is considered a contract. And so all of these fall under contract law. And most states are no-fault states, which means it doesn't matter what was happening. It doesn't usually matter if there was domestic violence. A divorce is a divorce is a divorce. Custody is determined solely by state law, which could either be the judge or an agreement of the parties. Abuse allegations can play a role in custody decisions, but they must be proven. And there is a huge crisis in the United States right now, and I'm sure a lot of you have heard of it, of judges not believing abuse allegations because they believe that it's one party or another trying to jockey for a better custody position. So abuse allegations, as much as it stinks, are really tenuous in custody cases. And then support payments and alimony, even if there is abuse alleged, support payments and alimony are governed by contract or prenup or whatever the state law is. And so abuse doesn't usually play into whether or not you get money. So we get a lot of victims that reach out to me and say, I'm going through divorce, my husband abused me, my husband abused our children. Unfortunately, we can't get a crime victims lawyer to help. You still need a family lawyer. So I have done, oh wait, I have more on family law. Again, litigants are not provided with an attorney. I covered all this. God, it's like I knew what slide was coming next. And I've been talking way too much. So with all of that, we're going to flip to the criminal justice system. And again, most of you probably know this, so we're not going to belabor this so we can really get into the meat of what we're talking about today. But Reed, do you want to give us an overview of the criminal justice system?
I would love to. But because as we've seen, most of the people attending here today are advocates and they work exclusively, it looks like, in the criminal justice system, I will be brief and I'll try to set it up by laying out some points that Ryan can distinguish when covering why the civil justice system is different. So the criminal justice system is initiated, and this is kind of one of the common questions, which is how do I do this? When a victim reaches out, you file a police report, right? Police in the city or the county in which the crime occurred. Crime is investigated by PD or sheriff's office. Finding a probable cause usually results in a yellow sheet or whatever the local language is, and they present it to the prosecuting attorney. That's another question we get. Who do I hire? You don't hire anyone. The state has an attorney. They're called prosecuting attorneys, and then they review the evidence that's passed on by police or the sheriff's department, and they look to determine basically, yes, it's a probable cause, but from a legal perspective, do I believe there's enough evidence here to where I can charge a crime? Their standard from which the lens that they're viewing the facts is that really high standard beyond a reasonable doubt. And I know it sounds like everyone's familiar with that. We're going to talk about a different standard that applies in civil cases, and we'll talk about why that different standard a lot of times allows us to take a closer look or a harder look at pursuing a case, a civil case, when a criminal case maybe wasn't feasible. And that's really hard to understand sometimes. But Ryan and I do not envy prosecutors because that is a really, really high burden to prove beyond a reasonable doubt. And it's frustrating to us sometimes. It's frustrating to our clients. And then let's see here. Perpetrators, they have that presumption of innocence. We've all heard that before, presumed innocent until found guilty. You won't see that in the criminal system. That doesn't exist. And then the purpose of, or the goal of the criminal justice system is to punish the wrongdoer and deter others from committing crimes. There's a different goal in the civil case. And then if that is achieved, the remedy provided for by the criminal justice system, it's not money, it's something like jail time, probation, community service, and the like. So that's the overview, and hopefully that covered. But if you have any questions, Renee, let me know.
Well, I think it's important to know too, what role victims play in the criminal justice system. And it's not much of one, frankly. It's, you kind of have a right to be present, but sometimes not. You have a right to notice, but if somebody forgets, there are not always remedies. So we have the Crime Victims' Rights Act that lay out the rights, but it doesn't have many teeth. And so there's really very little for a victim to do other than be a witness. So,
Yeah, and I think that's where we've always got to understand when a client comes to us, what stage is the criminal system in? Because a lot of times, whatever happens in the criminal justice system, it's not dispositive on what we decide to do. Meaning, we can pursue and often do pursue a civil case, even times where the criminal system has failed the victim and survivor. Again, we look at it through a different lens. But Ryan and I just want to make sure we understand where this family or this person is coming from, because it may be they just came out of a really frustrating criminal justice system that there was an acquittal, or they ended up not pursuing charges, or the police didn't do anything, and they're frustrated. They felt like they didn't have a voice. And a lot of times we can take over the case and provide the much needed healing and closure that they hoped that they were getting in the criminal justice system, but it was through a little different remedy, which was the civil courts.
well, and that gives us a great segue. So thank you. It's almost like you knew what was coming next. There are disadvantages and advantages that you'll hear from clients when they come to you, when they've gone through the criminal justice system. Do you both want to walk us through some of them?
Yeah, sure, Renee. As you said, the criminal side really isn't designed to protect the victim, right? But it can help them in a way that they can get a sense of justice, right? If the perpetrator is held accountable for what they did to that victim, then that is certainly an advantage. They're given the opportunity to face their perpetrator and tell their story, and feel like they've been heard, and that the society is protected from these things happening to other victims by this perpetrator. There are certainly disadvantages as well. Like it says, the victim usually doesn't have very much control. They're typically just a witness in the criminal case, and they don't get to decide whether or not charges are actually brought against the perpetrator, or what charges are brought against the perpetrator. They don't get to decide things like what depositions to take and what discovery to try to get. That's in the hands of the county prosecutor. Some of the disadvantages that maybe aren't listed here is, I'll give an example. A lot of prosecutors aren't really, what we call trauma informed or trauma trained. And in the Smith case that I mentioned earlier, I had a client who was 12 years old, and he had been horribly sexually abused by, a 65-year-old pediatrician. And there was some really horrible evidence in the case about some video evidence of some things that had happened to this boy. And the prosecutor, once he discovered this evidence, he wanted to ask the witness, the victim, about the video to understand what it was. And I still get phone calls from my client's family about this hour-long session that he spent with the prosecutor, where this prosecutor played the video 12 times, and they had to listen and watch this video over and over again. So there are certainly disadvantages of having to kind of relive this trauma, or be around prosecutors or other people that aren't necessarily in it for their feelings, but more so to convict the perpetrator, which is also important. But you know, their feelings and how they're affected, or what we call re-traumatized during the criminal process, can certainly be a disadvantage as well.
And Renee, this is probably one of the reasons you started off by letting everyone know that NCVBA is a great referral source, because of how you vet firms, and to just kind of feed off what Brian was saying and how we may handle it differently, or how a trauma-informed civil attorney may handle it differently, is that we're going to let our clients know from the very first meeting whether we're going to talk about the specifics of the trauma they went through. And we're going to tell them we're only going to talk about it one time. And it might be in the initial meeting. More times than not, it's probably not, because our attitude is that we're just, we're ambulance chasing attorneys. We're not. I don't think we are, but that's what people think. They don't trust attorneys, and we need to be open about that. And so our approach is that, hey, look, we appreciate you placing at least some type of initial trust in our firm and allowing us to review your case. But our attitude, we need to earn your trust, and it's not gonna happen in a day or a week. It's gonna take months and a year. And only when we believe that we've earned your trust are we going to ask you to sit down with us and go through and relive those horrible moments of the assault or the abuse that you suffered.
That's exactly right. And even then, Reed, I think you would agree that it's not always, we don't always, expect or force our clients to come into a room and sit down and tell us face to face. Sometimes it's best for that victim to write it out and send it to us in an email or a letter, to where they don't have to actually speak it out loud for the first time. Sometimes it's better to do it, maybe with one of our female paralegals or staff. Maybe they feel more comfortable speaking with them about this first. So it's a process of earning their trust, and we certainly don't expect them to just trust us right off the bat. So that's exactly right.
Yeah, and that's a great point. And we've got a couple of slides at the end for everyone on how to kind of vet the attorneys. One thing that we're all hedging around, but it's a very real thing, is victims' expenses are paid by who after a criminal prosecution, and well, they're paid by victims. As being a victim of crime is very expensive, and so I would love for one of you to walk through Missouri crime victim compensation and restitution, because I've got to be honest, it's one of the more complicated states that I've seen.
Yeah. And I actually pulled off their informational packet because I wanted just to make sure. I feel like it's changing ever so often, but this is a brochure you can get from, where did I pull this? I think if you type in crime victims compensation, it'll pull you to the government's website. But let's just talk about some of the eligibility requirements. Crime must have occurred in Missouri. Application for crime victim compensation has to be filed within 2 years from the date of the crime or the discovery of the crime. The crime must be reported to the proper authorities, who is considered law enforcement and prosecuting attorneys. Victim must fully cooperate in law enforcement investigation, and the victim must not have contributed to their injuries or engaged in provocation/enticement. In terms of benefits that could be provided, maximum benefit per crime is $25,000 and could include some of the following items: medical expenses, including prescriptions, counseling expenses, funeral expenses, lost wages up to $400 per week, and loss of support. And I'll kind of try to wrap it up by it. As Renee said, the state pays for the prosecution through its prosecuting attorneys. There's very little by way of justice for the victim through the criminal process. Restitution is limited, as we can see. No one in their right mind is going to say that an award not to exceed $25,000 is ever going to get anywhere close to what we call full justice. And here's a piece that's not included that every victim and survivor interested in pursuing a civil case should at least be aware of, is that if you get a civil recovery, it is more than likely that you are going to have to pay back the state of Missouri or the state of Kansas if you get compensation from the crime victim fund. And I'll just tell you, I just went through the board in Kansas with this, and to their credit, they were phenomenal. They had, I don't know, 15,000 I think paid out on a single claim, and we had a limited recovery for a victim because of the insurance policy limits were limited, and we went in and asked for a reduction, and a very nominal reduction, and they were great. They worked with us. They agreed to the reduction and they took pennies. The state did on the dollar based on what they actually provided in compensation to our clients. So there can be some they can be great to work with if there is compensation paid.
So crime victim compensation is paid for by the state, and then there's an idea of restitution. And I will say this would be the one that has some interesting caveats that I've not seen. Does one of you want to explain restitution?
Sure. Yeah. So restitution is paid by the defendant and ordered by the judge. It's here's what I'll say is we don't see this a lot, at least in our practice area. And maybe that's because at the time that it's placed on our client's plate for consideration, we're kind of, they're getting the messages for the prosecuting attorney like, hey, look, it's pretty limited. It's probably going to be a couple $1,000s. And, you know, do you want to do it or not? Now, if they don't get a response from our client, I think most of the times the prosecuting attorney is probably going to err on the side of asking the court for restitution. Whether or not it's actually ordered is one thing and paid is another. But we don't see a lot of that in our cases.
Okay. So I think all of this goes to say that there are some advantages to the criminal justice system. Sometimes you don't have a choice, but there is, even in the cases of a very successful prosecution, the perpetrator is going to jail. A victim can feel left out. They could still have a variety of issues that haven't been addressed. And so there's an alternate, which is the civil justice system. And that's what we're here to talk about. So this is something that Ryan Reed and I spent an entire year learning in something called torts law. We're going to give you an overview of torts law in about 45 minutes, which will be exhausting. Starting with Ryan, you want to give everybody a brief overview?
Sure. Let's first talk about the parties of a civil justice or a civil lawsuit. The plaintiff would be, in this case, the victim or the victim's family. A lot of the times our clients are minors when the lawsuit is brought. So it's brought through what we call a next friend. And this is typically a parent or a legal guardian that consents to be the next friend and kind of take the place of a minor, because as we know, minors can't be the plaintiffs themselves. The defendants are, there's a huge list of people who could be the defendants in a sexual abuse case. Obviously, the perpetrator can be named as a defendant. And then, you know, it's usually the third party defendants are usually employers, co-workers, parents, supervisors. There's a whole litany of people who can be held liable civilly for allowing these crimes and this abuse to happen. Rarely is the perpetrator the one that we're really going after in these civil lawsuits for multiple reasons, which we'll talk about in more detail. But the main one, you know, when it comes down to it, a civil lawsuit is really about money, right? We're trying to get monetary compensation to help the victim, right? To make them whole, as Renee said, or find full justice, right? And usually the perpetrator himself doesn't have an amount of money, and if we go get a big judgment or verdict against a someone, it's usually worth about the cost of the paper that it's written on. So it's usually third parties who we're looking at for failure to supervise or negligently retained the perpetrator that kind of facilitated the area where this abuse took place. In a civil lawsuit, the burden of proof is significantly lower and different than a criminal case. As Reed was talking about it, that high burden in the criminal justice system is beyond a reasonable doubt. Here, the standard is that the defendant's behavior more likely than not caused harm to the victim. So, what is more likely than not? It's kind of hard to explain. You'll see a lot of attorneys, when they're explaining this to a jury, get a book and divide it in half. And if you say we have 1 page of evidence greater than the defense, then we win, right? So just more likely than not is the burden in the civil justice system. And that's for compensatory damages. And we'll talk about punitive damages in a little bit. And the burden of proof for punitive damages is different and higher. Another big difference between the civil justice system and the criminal justice system is that there is no presumption of innocence, right? I think Reed covered in the criminal justice system, everybody is presumed innocent until proven guilty. That's not the case in the civil justice system. All you have to show is that they were more likely than not that their actions caused the harm to the plaintiff. You want to keep going, or is that a good stopping point, Renee?
I was home for Thanksgiving, and my mom loves the show Hot Bench, which as an attorney is really shameful to me. I am ashamed. If you've seen it, it's 3 judges, Judge Judy style. And actually on Friday, they had a discussion about what preponderance of the evidence was in civil cases. And I got so excited because I was like, I'm going to talk about that on Monday. And they kind of described exactly the way you did, just maybe a little bit more likely, maybe a little, just super legal term.
Yeah, you see lawyers get very creative with how they describe it. You have 2 buckets of water that weigh the exact same, and 1 extra drop of water in the plaintiff's bucket means we win, right? So you can get pretty creative with how you describe that, but it is a much lower burden than the criminal system.
Yeah, and defense attorneys who are most often hired by insurance companies to defend either the perpetrating defendant or these organizations, right? They know and recognize how powerful it's not low. It's a fair burden of proof when you're dealing with money. The beyond reasonable doubt, and when you look at our Constitution and how our founding fathers set it up, you are looking at the potential deprivation of life in the criminal system, liberty. And so they set what they believed was an appropriate burden of proof. We're not dealing with that in the civil system. We're dealing with money. And so when our justice system was founded, that's where you get preponderance of the evidence. But in civil cases, what we often see is the defense attorneys know that that's a tall task for them. And for us, whatever analogy you like to use, I always use the scales of justice, and you put a feather on plaintiff's side and it moves it, that's enough. But what we see defense attorneys before trial file motions with the court for trying to prohibit us from educating the jury on what preponderance of the evidence means, trying to get them educating them on how they're going to be instructed, and using these things like Brian and I are talking about, whether it be the sheets of paper, the scales, or even just saying it means 50.1%. And so that's something that's constantly on the attack, but it's just basically saying what the law is. We always think it's kind of funny, and yet I have seen a judge deny those or allow those attempts to prohibit us. In other words, they allow us to explain those things.
That's convenient and handy. Let's talk about torts and what they are. So everything that we're probably going to bring in these types of cases are going to be based on torts, and there are intentional torts and there are negligent torts. Reed, do you want to explain intentional torts?
Yes, these are the torts that don't often allow us to get a recovery for our clients. First, the negligent torts, they do. And that's because of the way insurance works. But from Renee taking us back to law school, and we were learning what these are. Intentional torts are the types of claims that are asserted typically against the perpetrator, himself or herself, for the harm that they've caused. And I pulled one up just here in our jury instruction book. This is how jurors instructed. And an example would be assault, or another example would be battery. And they're very simple. An example would be if you brought a battery claim against a sexual battery claim against a perpetrator, and the jury was to deliberate after viewing the evidence, they would be instructed, your verdict must be for the plaintiff if you believe, first, the defendant intentionally assaulted the plaintiff, and second, defendant thereby caused plaintiff bodily harm. That would be an example of an intentional tort. And I'll let the transition go to Ryan here in a minute to explain why we certainly consider these claims and oftentimes plead them in the initial pleadings, called the complaint or the petition against the perpetrator. But intentional torts, from our perspective, are typically not covered by insurance, which is where the vast majority of recovery comes on the civil system.
And they're pretty easy. The defenses to them are pretty much what they are in the criminal justice system. Wasn't me. I had consent. I was defending myself, or I was defending somebody else. I always say that, and then I have to add the caveat, and I didn't understand this until I had a dog. Defense of others must be people. You cannot defend your dog with any type of force, even though if somebody came after Jack, we'd have words, but defense of others does mean people, not pets or property. We'll skip examples of it. Okay, negligent torts. Ryan.
Yeah. So the concept of our claims usually sounding in negligence as opposed to intentional torts is something that isn't intuitive. It's something that we have to spend some time explaining to our clients, because I always explain it like this. If I'm driving down the road in my car and I see someone that I don't like and I intentionally run them over with my car, right? My auto insurer is not going to cover that claim, right? That's an intentional crime. That's an intentional act. And I have never seen an insurance policy that doesn't exclude intentional crimes or intentional acts. It's claims of negligence that are typically covered by insurance. So while even if we're bringing a claim against the perpetrator in the civil justice system, we'll still likely bring it titled negligence as opposed to an intentional act of assault or battery or sexual assault, because of the insurance piece. And every once in a while, depending on the policy, there's lots of sexual abuse exclusions and lots of laws that say even if it's pled in negligence, if the conduct was intentional, it's still not covered. It's still worth a shot, right? To plead as in negligence as opposed to an intentional crime. But most of our claims are really not against the perpetrator themselves. They're against a third party, and those are claims of negligence. And like this says, it involves harm caused by acting or failing to act with due care where harm was foreseeable. Usually third-party defendants like teachers who negligently supervised other staff, or boarding school directors who knew the staff was behaving improperly and allowed it to happen. Employers who are not meeting up to the industry standards when it comes to background checks and vetting employees, things like that. Those claims of negligence are ones that are usually covered by insurance. So those are the claims that we usually bring. The examples, I think maybe the next slide potentially would be negligent. Yeah, maybe
No,
not.
we got to explain what negligence is before we get into
Okay,
examples.
all right. So yeah, what is negligence? There are really four elements to a claim of negligence. One, you have to establish that there was a duty to the plaintiff, right? And then that there was a breach of that duty, and that breach caused harm, and that the damages resulted from that harm. And that sounds simple, but you can't just sue someone for negligence if they didn't have a duty of care to the plaintiff. For an example, in the Smith case I've been bringing up, we brought a claim against the pediatrician's employer. Now, why did the pediatrician's employer have a duty to the plaintiff? Well, because he was a patient of theirs, right? And if you're a patient or a customer of a business in Missouri, then they typically have a duty to you to make sure that their employees who are going to be around you are safe, right? We also brought a claim against the perpetrator's spouse because some of the abuse happened at their home. Now we had one of the big issues in the case was establishing that the spouse had a duty to the plaintiff who wasn't her son or her child, but we established a duty because she knew that the boy was over at her house. She had taken pictures of him playing basketball in their driveway, and even videos of her telling the kid to leave. So we established that she had a duty because she knew he was over there and was really under her supervision. Now, just because you have a duty doesn't mean that you're automatically liable. You have to breach that duty or do something that's that's against the industry standards or the standard of care that then caused harm, right? So in the same case, for example, when we brought a claim against the employer who had a duty to the plaintiff because he was a patient, we had to say that they breached that duty. And what was the allegation of breach? Well, we usually in a case of negligent employment or negligent hiring, you have to show that they shouldn't have hired this guy, or that person shouldn't have been around this child, and that's what caused the harm. And in that case, we found that the breach was, well, he had done this before at a prior employer and been fired for it. And they failed to do a proper background check and find out those things. And if they had met their duty, then this harm would not have happened. And then obviously, because of that breach, harm happened, the abuse happened because of that breach, and that the damages were the proximate cause of that harm. So those are the general elements of a negligence claim.
And I do want to go back to this slide really quickly. I forgot to mention it as well, and I think it's a super important point. The reason that these negligence claims are so important is because they are what allow attorneys and victims to hold wrongdoers outside of the perpetrator accountable. And the criminal justice system does not really recognize a concept of negligence. And probably the most famous of the cases, or best example, is the Olympics cases. So there's a law professor out of Utah named Amos Giora, and he interviewed all of the Olympic gymnasts who were abused by Nasser. And they said it wasn't even Nasser that they were angry at in the end. He was convicted, he had crime, but USOC and University of Michigan and Penn State and the Catholic Church and on and on and on, they know this is happening. They're actively doing wrong, and there's no way to hold their feet to the fire unless you're in the civil justice system, because criminally, we don't recognize negligence. So I did want to point that part out. So back to potential defendants, and we've covered some of this, but who are we talking about? And whichever you wants to take this one.
Sure. Obviously the offender for first party defendants, like Reed was talking about, that's your perpetrator, people who co-conspired in the abuse, people that were there who were actually a part of the crime itself. Now it says, let's talk about why these aren't always the best options. I kind of got ahead of that and described that earlier, that, it really comes down to insurance and money. And unfortunately, a civil claim, does kind of revolve around money, because that's what we're trying to do, is get these victims and survivors compensation for what they've been through. And the best option for recovery is really against third parties for claims of negligence that insurance policies cover.
Yeah, and we might cover this later, and I frankly can't remember right now, but in Missouri and Kansas, if you bring both the perpetrator and the institution, what are jury instructions? Is it comparative fault? How does that work? And explain what I'm saying, because I'm using words that aren't very common.
Yeah, comparative fault. So, we have a big decision to make. We typically name both parties, the perpetrator as well as the third party. When it comes down to which parties we're going to put on the verdict form at trial, that's a different question, because of the issues that you've just brought up, Renee. If you go to trial and you say, hey, the employer is at fault for negligent hiring, and the perpetrator is at fault for the actual crime or the actual assault, the employer defendant is going to have a pretty good defense of saying, hey, even if we are at fault, we're a tiny fraction of the percentage of fault as the actual perpetrator. He's sitting right there. Give them 100% of the fault. Give them 99% of the fault. And if that happens in Missouri, then whatever verdict that the jury comes back with in terms of a monetary number will be reduced by the percentage. Like, for example, if they give 90% of fault to the perpetrator and 10% of fault to the employer, well, then the employer is only going to be responsible for 10% of the verdict. So it's really important to think that through when you go to trial. And there are different schools of thought, right? If you want to try to get rid of the comparative fault, you can get rid of the perpetrator and not put them on the verdict form, and dismiss them from the lawsuit before trial, so that the jury is only looking at the employer or the third party defendant. Another school of thought would be to leave the perpetrator in and to really inflame the jury and get that damages number really high. And so even if the percentage of fault is lower for the employer, the third party, it's still it's a percentage of a much bigger number. So there are different, strategies in terms of who you actually name at trial in these cases.
Yeah, and just the big difference between Missouri and Kansas is that in Missouri, only a party to the lawsuit can be on the verdict form for the jury to determine and assign comparative fault, that percentage Ryan was talking about. And so that's why it's a big decision. And a lot of times, if you'll see attorneys dismiss the perpetrating and defendant from the lawsuit before they go to trial against the third party. But by contrast, in Kansas, even regardless of whether the person is a party to the lawsuit, if there is evidence that they bear contributory or comparative fault, they can be on the verdict form for the jury to assign a percentage of fault to them. And more importantly, unlike Missouri, which follows pure comparative fault, that's what Ryan talked about, meaning a plaintiff can recover even if they are found to be 99% contributory negligent. So an example would be if the jury awards $100,000, the plaintiff is found to be 99% at fault, the third party is found to be 1% at fault, technically the plaintiff could still recover $1,000. And by Kansas, though, and this is why it's I think a lot more difficult. Not only can the defendant point to anyone they want if there's any evidence that they were at fault, but if a plaintiff is found to be 50% or more at fault, zero recovery. That's the way it works. 50% and the plaintiff is out, no recovery. And so you just have to make sure you're hiring attorneys who understand how comparative fault works, understands the strategies of who to place in the lawsuit as parties and on the verdict form of trial.
And that is coming up so quickly, is the importance of what attorneys can and can't do and shouldn't know. But before we get into that, let's just run through some of these third-party defendants for ideas. I will let you both take it away. If you want to give any examples you have, they're pretty self-explanatory, but maybe they're not. Maybe if there are good examples on here that remind you of something.
Yeah. I'll go through. So Ryan was talking about duty of care. And with the first one, landlords, hotels, hospitals, the reason that there's typically a duty in those cases is because when there is a criminal act by a third party, and that's a different use of the word third party, but a perpetrating defendant in, let's just say, a hotel, and you've got a hotel guest, the guest is assaulted, and maybe it was someone unrelated to the hotel, but it was someone off the street who came in and sexually assaulted a guest. The law typically provides a duty of care for hotels to their guests because it is a recognized special relationship between innkeeper and guests to keep them safe. And so that's the analysis that you'll see in most of those examples in the first example. Employers, Ryan covered a lot of these. Their duty is built upon either foreseeability because they had some prior notice that there was harm caused by the perpetrator, or another example of duty Ryan provided is that they have a duty to make sure to properly vet their employees and that make sure they are fit for employment or that they're safe. Nursing home and child care facilities, youth serving organizations, social hosts, same thing generally is that there'd be a recognized special relationship as the owner or operator of a premises and its invitees and licensees. In residential facilities, it's the same thing, innkeeper and guest. Brian, you want to talk about social hosts and tavern keepers in terms of how that works with Dram Shop?
Briefly, I mean, I don't think it should be a key, but yeah, in bars and things, if a bar or tavern can be held liable for over serving, if they knowingly serve someone who's intoxicated and then that intoxicated person goes and commits some sort of negligent act or intentional act, and they can be held liable. One point I want to talk about, just because it's kind of been something that we as a firm have been dealing with a lot. You see hospitals and nursing home and child care facilities. One thing that the defense will bring up a lot is medical malpractice, right? If you bring in negligent supervision or negligent retention claim against a healthcare organization, they're likely going to say as a defense that, hey, whatever claim this is, it's capped by the medical malpractice caps in Missouri. And there's been a lot of case law recently and a lot of cases in lower courts and Court of Appeals looking at this issue as to what is medical malpractice and in terms of sexual assault, right? I mean, obviously, the act of a doctor or a certified nurse practitioner assaulting or sexually abusing a patient, that isn't medical malpractice, right? But is the claim against the hospital for supervising that patient or supervising that staff member, is that medical malpractice? And that's a much more difficult question that often comes down to what were the exact acts that were taking place, and was it in the place of rendering or failure to render healthcare services, which has been a really interesting question that a lot of courts in Missouri have been looking at recently. But
yeah, how does the cap work in Missouri? What's the number? And is it on all the damages?
Wait, we're not there yet.
Oh, okay.
We're not there yet. Settle down. As an aside, we do have an amicus committee. If one of those cases comes up and you all need an extra little writing for that, we'd be happy to do it. Okay, now we've set the table. Everybody now has a background of how a case proceeds through civil court, of why we're even here, what some of the advantages and disadvantages are there. That's all basic torts law, basic plaintiff's personal injury law. Where we get into the meat and potatoes, and really what we're here to talk about today, I still have Thanksgiving on my mind. I can't get away from potatoes. But what we're really here to talk about is the special considerations for victims of crime within the court system. We've talked about a couple of them, but we're really going to delve into them now. They are the reasons it is so incredibly crucial to find the right attorney. I think a lot of folks probably heard in New York, the Diddy case, one of the victims had to be named, and the judge found that her case would be dismissed if she was not named and would not allow her to file under a Jane Doe filing. I will tell you, I looked at the complaints, and that was solely the attorney's fault. That was just a poorly pled complaint. And if you don't know how to handle these cases, and if you're not a specialist in these cases, those are very easy mistakes to make. So that's why it's really so critical to find the right attorney, and not just for legal technicalities, but attorneys who are trauma informed and know how to handle victims appropriately. We're going to go over some challenges, and I always make sure to emphasize this. A lot of these challenges are reasons that attorneys will not take certain cases. I get a lot of very frustrated emails from folks who are looking for an attorney that I could not refer. It's not that the case isn't good. It's not that we don't believe the victim. It's not that we don't think it didn't happen. It's that there are so many complexities in these cases and reasons to take it and not to take it that we're going to go over, that a lot of times it's just better to not go forward with the case because some of the barriers are just impossible to overcome. So we're going to talk about statutes of limitations, damages, a couple of other things, and then get into what makes a good crime victims attorney. So let's start with statutes of limitations in civil cases.
Yeah, Renee, one of the hardest parts of Reed and I's job is how many cases we have to turn down, right? I mean, I think Reed had looked at the numbers, and we turn down 95% of the cases that that call us because of some barrier that we can't help them. And the last thing that we want to do is put them through litigation, which is a traumatizing event in and of itself, only to get them nothing, because that typically leaves them worse off than they were. So properly vetting the case is just as important as anything, because you want to make sure that you're not bringing claims that that don't have a good chance of being successful, because you could end up doing more harm than good. One of the biggest reasons we have to turn down cases is because of the statute of limitations. And I'll talk about in Missouri, because I'm not licensed in Kansas. Reed can talk about that, so I'm not committing some malpractice. But in Missouri, every state is different on their civil statute of limitations cases deadlines. But a statute of limitations in general is a deadline on when you're allowed to bring a claim. In Missouri, the general negligence statute is 5 years. Okay, so from 5 years of the time of the alleged negligent act, you have to bring a lawsuit. Now, if there are all sorts of caveats to that, right? If the victim of that negligence is a minor under the age of 18, then that 5-year time period is tolled until the victim turns 21. So effectively, it is the victim's 26th birthday that they have, if they were abused as a minor, to bring a claim against a third-party defendant. Okay, that's where that 5-year negligence statute comes into play. There is two other things. One is the 3-year discovery. Typically, there's a special statute for child sexual abuse in Missouri, where as opposed to a 5-year statute from age 21, it's 10 years if you were a victim of child sexual abuse, but that statute only applies to the perpetrator, right? So if I was going to bring a claim against their employer for negligent supervision, I still have that age 26 deadline. Missouri does have a case that talks about tolling of the statute of limitations for discovery. And what we usually call it the repressed memory doctrine, or the repressed memory tolling provision, that if a minor is abused or assaulted in some way, and they repress that memory and don't ascertain their loss. I know that's a legal term, but it's a difficult thing to really uncover. And let's say that they repress that memory, and then when they're age 25, they see an article or they remember what happened to them, then they now have 5 years from the time that they discovered that loss. That's obviously very difficult to prove. You know, if that victim had ever disclosed the abuse to anyone, or if it's in any counseling records or anything like that, then you're not going to be successful in a tolling claim. But that's the general
And
statute.
Ryan, let me jump in, just because I know you and I, we looked at this all the time, but in Missouri, one of our best cases that we can go on to try to figure out, like, what do we tell our clients in terms of, do you meet the tolling exception or not? But in 2006, there's a case called Powell versus Chaminade College Preparatory. And we believe what the court told us in terms of when discovery occurs. So then when we can talk to our clients and say, you have a timely claim or not, is the court has told us there's two components. One, you recognize that the wrong had occurred. So there was some type of assault, abuse, or crime. Plus, and here's the second component, you recognize that the injury or the illness was caused by the wrong, or you have sufficient facts to be put on notice. And that still leaves attorneys practicing in Missouri with kind of a guess as to whether this is met or not. The best thing we can tell our clients is that, to Renee's point, find an attorney who knows how to evaluate the case, plead the case in the initial pleading, whether it's petition or complaint, and then set it up to where this question becomes a fact question. That's what we believe these courts are telling us. If it's a fact question, it means that the court can't decide it as a matter of law, and it goes to the jury. And at least then, if you can set it up right, it's a fact question, you can give your clients their day in court with a trial. Otherwise, what you're going to see is like a court who didn't allow a victim to proceed pseudonymously, or a court that's going to dismiss a case on a motion to dismiss or a summary judgment motion before a victim or survivor ever gets their day in court.
Yeah, and talk about like a psychologist who can testify as an expert to repressed memory and how that can help set that up.
Yeah, we routinely, Ryan and I, there are so many things Ryan and I would love to just spew in open court, but we're not qualified as attorneys. You have to go on the evidence. And the evidence that we're talking about here is this is why being a part of an organization like NCBA is so important. It connects us with not only great people and attorneys, but a good database of experts. And we have experts evaluate our clients, put them through an evaluation. And when they meet the criteria, a qualified expert can testify to repression, or as you'd often hear, disassociation. And that helps create that fact issue so that the judge can say, hey, look, we believe it's not clear. We're going to let this evidence play out in front of a jury, and the jury gets to determine whether or not this should have been discovered earlier or not as part of their verdict form.
And I will this is one place where we see a lot of attorneys who are not experienced in working with crime victims really mess up cases. There's one case in particular with an attorney I do know who's not an NCVBA member. He blew a whole case because he allowed his client to have a press conference because he wanted the media attention. And during that press conference, she stated that she knew when a certain injury had occurred, and she blew her statute of limitations right out of the water. Whether she misspoke, whether a couple of things, but it's these are very delicate issues. Do either Missouri or Kansas, are you all talking about window legislation? Has window legislation come up? No.
Yeah, I mean, yes and no. So Missouri and Kansas, as everyone who practices in the area knows, obviously a very conservative part of the country, and SOL reform has been tough to come by. But so here's where we stand, and try to do my best to give you a quick overview. So we saw some recent change in Kansas, moving the statute of limitation from a victim's 21st birthday to their 31st birthday. Okay, not great, but better than it was. And so victims would have, regardless of whether you're bringing claims against the perpetrator or third party, your 31st birthday, or, and the only exception is you could bring a claim even after 31 if it's within 3 years of a criminal conviction. 3 years of criminal conviction. Now, Missouri, as Ryan said, it's still age 26 for really the claims we're concerned about. We've had great momentum in our legislature in Jefferson City the past 3 years. Ryan did an awesome job last year testifying in support of House Bill 1617, which, as introduced, would seek to expand the age to age 41 or 42, I believe, and even got through the House, passed unanimously, but it's just, it was just really late in the session and didn't get through the Senate. But I know we're gonna have a lot of bills pre-filed this year for the 2025 session. We're confident at this point that it's only a matter of when, not if. And there hasn't been a specific conversation on a window in Missouri. Hopefully it gets added. We would certainly love to see that. Our biggest fight right now, Renee, as you know, is, some states have seen this legislation pass, which would extend the statute of limitations till, let's say, age 52, but it only applies forward. And so meaning people who are time barred currently, their right isn't revived because there is a question of whether or not going backwards in time violates the Constitution. And so we're working hard in Missouri to put a constitutional amendment in place, which would then go to the ballot for a vote and cure that deficiency. But again, we're working hard and with great groups like NCVBA and some of our other local coalitions to try to get this thing through.
Awesome. It's one slide for statutes, but it's always one of the most confusing areas of the law. So I want to pause. I'm not seeing any questions, but we are going to move on from statutes. So if anybody has questions, now is the time to start popping them in the chat.
I would just say really quick, Renee, I mean, the reason the statute is so important and the reason we're working so hard to try to get the statute extended is because in our experience, it takes victims so long to have the courage to come forward with what happened to them that oftentimes it's after age 26. Reed mentioned we testified in front of the House last year, and another lawyer testified. He did a great job, and he's a big, athletic, strong guy, and he came forward while he was testifying about how he was abused as a child. And his kind of, his what he said was, I feel like if anyone's going to be strong enough to come forward with what happened to them, I'm kind of the stereotypical guy who should be able to do that. And I wasn't even able to come forward with what happened to me until he was like 33 years old. So it just goes to show you that the 26 deadline is just far too short to give these victims and survivors a chance to come forward with what happened and seek justice.
Yeah. Important to note, statutes of limitations serve a purpose, and the purpose is to preserve evidence, to preserve memories, to ensure that memories can't be questioned too far in advance. But with a lot of these institutional defendants that we're seeing who are relying so heavily on the statute of limitations, the issue is they're using it as such a shield. And for example, there's a very famous Pennsylvania case, Rice versus the Altoona Diocese. A woman, Renee Rice, had sent a letter to the diocese saying she was abused by her priest, but that she wouldn't take action, but she wanted them to know to protect other individuals. The church wrote back to her and said, "We had no idea. This was all shocking, stunning, amazing. We had no idea he was doing this." 10 years later, when the very famous Josh Shapiro report came out, turns out that priest had abused 30 people well before Renee Rice, and the church was very well aware of it, but they had actively lied to her to basically avoid the statute. And the Pennsylvania Supreme Court said it didn't matter that they lied, that they could rely on the statute, and they were their lying didn't toll the statute. And so it just, there are reasons for the statutes, but with a lot of these institutions, we see them keeping the evidence and hiding it, which is not in the spirit of the statute. Let's talk about damages, because they're a little bit different in crime victims cases. Compensatory, economic, non-economic, punitive, all a lot of big words that really affect crime victims.
Yeah, I'll take compensatory damages. These are the ones that you would see in any case. Just from the get-go, if you file a petition and you have a viable claim, you get past the motion to dismiss, and you're prepared for trial, the victim or survivor would be entitled to present a request to a jury to be compensated for the harm that they've suffered and will suffer in the future. And in order to submit that to the jury for future, you have to have some evidence, typically in the form of qualified experts, that this is a permanent injury. And so here's what I kind of want everyone to understand is the question we get, and why you have to get an attorney who knows how to present these issues to a jury, is most oftentimes victim cases, there aren't significant economic damages. Economic damages are things like medical expenses and lost wages. Those are typically pretty nominal compared to, for example, a car crash case and someone has broken bones with lots of surgeries. You're going to see significant economic damages by way of hospital bills, hundreds of thousands, if not millions of dollars sometimes. And so in crime victim cases, you have an election of whether or not you even make a claim for economic damages. And most times our philosophy, and people think differently about these issues, we don't submit economic damages, because if you do, and let's say, you've got $15,000 in medical bills, a smart defense attorney will use that to anchor. That's a tactic in which they tell the jury, hey, look, the victim is asking for millions of dollars, but look, they only had $15,000 in medical expenses. We believe that's fair. That's what you should give them, and that's it. Okay. Why we focus on the non-economic damages and don't submit economic is because tactically we remove the anchor. The defense attorneys can no longer present those numbers or use that argument. But the non-economic damages is where the human story is at. And this is the hard part, but it takes getting to know your clients, spending time with them, having them in your office, spending time in their home, and really being able to present. And here's how it usually comes out in the verdict form. You're asking the jury to award damages for pain, suffering, mental anguish, loss of enjoyment of life, and disability. And yes, the plaintiff can talk about those things. That's great. But here's how we think of presenting this. We want to present our plaintiff when they testify as in terms of what they're doing to get their life back on track every day, kind of the hero mindset. Okay. And what we found through our research and work with experts is that a jury would much rather hear from a person who's working every day to get their life back on track, as opposed to all the things they're still struggling with, even though we know it's apparent. What we do to present that side of the story is bring in the people that know them best. We call these before and after witnesses. They can be family members and friends, but they can also be colleagues and other people that don't have as directly close a tie. And so when we present this non-economic piece, again, it's hard to attach a dollar amount because you don't have a lost wage, like a pay stub, or you don't have the medical bill. And so what we do is we really get to know our clients. We present their story through typically the people that surround them and know the best. And then what we're considering is as we know, we think of every sexual assault as being a 10 out of 10 and more than likely being an indefinite injury for the rest of their life. We call them forever injuries. And so a lot of times we'll use a victim's life expectancy. And for instance, if their, life expectancy according to the governmental statistics is 20 years, a lot of times we'll use that number to ground our ask, and it might be $20 million. And that's how we explain non-economic damages to a jury when we don't have like a receipt or a pay stub to provide kind of that basis for it.
Yeah, I think that's a great point. And a lot of that too is you can't see, it's easy to bring in somebody who's lost a leg, and you can see that. You a lot of times can't see the damage and the harm that victims have gone through. Punitive damages are a little more tricky. Ryan, would you like to explain them?
Yeah, so obviously the compensatory damages are meant to look at the plaintiff, him or herself, and say how much has he or she been damaged and how can we try to make them whole or give them justice. Punitive damages don't look at that. They look at how do we prevent this from happening in the future. And these are important because these numbers can get really big, right? I mean, if you have a big institutional defendant that has acted really bad, then a jury can really get inflamed and throw a big number against the defendant to try to prevent this from happening in the future. And this isn't tied to damages, to compensatory damages. So it doesn't matter how much the plaintiff was injured. It matters how bad was this conduct and how much do we want to punish them so that they don't do it again and so others are deterred from also behaving in this manner. And you can't always just at the end of the case say, okay, give us a bunch of punitive damages as well. There's a higher standard for when punitive damages are allowed. I think it was 2020 maybe when the legislator changed the statute in Missouri, but before that, you could bring a lawsuit and add punitive damages to the lawsuit and just plead from the get-go, hey, we were going to ask the jury for punitive damages. And then at comes the trial, you can tell the jury, hey, we'd like punitive damages, but you had a higher burden of proof. You had the clear and convincing standard, meaning that the jury is not allowed to give punitive damages unless they act reckless. Their conduct was so clear and convincingly true that the punitive damages were warranted. The standard has now been changed to where you can't even plead punitive damages in the initial complaint anymore. What you have to do, the process is a little complicated. You plead your complaint without punitive damages, and then once you have sufficient evidence, you can then file a motion to amend your complaint, and you now have to convince the judge that it's reasonable that a jury could, based on a clear and convincing evidence standard, award punitive damages. So you kind of have to go through the court system and through the judge in order to get punitive damages presented to the jury, which is an extra step that you used to not have to take, but now you do. And when are you allowed to bring punitive damages? The statute, it's 510-261, and it says that except as otherwise provided by statute, punitive damages shall not be awarded unless the claimant proves by clear and convincing evidence that the defendant intentionally harmed the plaintiff without just cause or acted with deliberate and flagrant disregard for their safety. Okay, so it's that higher, more reckless or more flagrant or deliberate conduct that gets you to punitive damages. If it's just mere negligence, there was an accident or was an overlook, that's generally not going to raise to the level of punitive damages. But if there's that extra deliberate or flagrant disregard or reckless conduct, then a judge will allow you to present punitive damage to the jury and ask for those extra damages. Last thing I'll point out on punitive damages is if you do have like a negligent hiring case or a case against an employer of the perpetrator, there's a special provision in the statute for punitive damages that allows you to recover punitive damages against an employee if the agent was unfit and the principal or managerial agent of the principal was reckless in employing or retaining him or her. So that's kind of a lower standard than the scary language at the beginning of the statute of flagrant disregard and deliberate indifference or intentionally harm. So it's almost like there's all you have to do is be reckless if you're an employer and you're hiring someone to get to that punitive standard threshold. Whereas if you're not an employer, it's a kind of a higher standard. So it goes to show if you're employing someone, you better be careful of who you're hiring, especially if they're going to be around vulnerable people, and you need to do your proper background checks and make sure you're properly vetting someone, or else the punitive damages statute allows, punitive damages to be awarded in those types of cases. And the last thing, they are capped generally. I mean, if generally it's 5 times the compensatory damages or $500,000, whichever one is higher. So, they can still be a very high number.
Does Missouri take any of that? In some states, the state takes anything over 50,000.
Yeah, what is it, 10%, Reed?
Okay.
Well, a little higher. So I don't know if we have a slide on this, but in addition to the Crime Victims Compensation Fund, in Missouri, we have a Tort Victims Compensation Fund, and that fund is funded from punitive damage verdicts from juries. 50% of the award goes to the fund.
Jeez.
Yeah.
And that fund is used to, let's say you have a client that that maybe there is no insurance proceeds, or you get the maximum amount, like the caps of the insurance, and that wasn't close to coming to the damages that that they should get. And you can apply for an additional, I think it's up to $300,000 that would come from the Tort Victims Fund, and that's how it's funded, is through punitive damages.
Okay. So we have covered the entire civil justice system up to damages. We are running a little behind, but I want to make sure that we hit some of this. We're just going to do it quickly. So I think, as we all discussed, there are definitely advantages to civil litigation. We've covered pretty much all of these. The only ones I think we really haven't covered were incentives for crime prevention and to promote change or publicize the issue. And I will just say that goes a longer way than people realize. The Catholic Church cases, the Olympics cases, those institutions knew about things for years. And even with the press, they weren't changing until you started to hit their pocketbooks. There was no incentive for them to change. And so as much as we've talked about, people like to rip attorneys, the attorneys that are doing this work, and the newest one is gun control, frankly, not getting political, but making sure that guns are in the hands of safe people. The attorneys that are doing this work are really starting to turn the tide. So there are all sorts of advantages, but I do want to make sure we go over quickly, not necessarily the disadvantages, but some of our concerns and some of the things we look at. So either Reed or Ryan, do you want to walk through the disadvantages and kind of give some examples? Well, wait, let me ask this first. In the chat, while they're explaining this, can you all put who has ever seen a deposition, actually a live in-person deposition? And then can you all explain the disadvantages of the justice system?
Sure. Yeah, I'll take the first one. We, as attorneys, fund 100% of our clients' cases. And the client only bears the expense to the extent that we've successful in recovering them money, and our firm gets reimbursed, or an attorney's firm gets reimbursed from the recovery. And that's the contingent fee system that I think every plaintiff's attorney generally across the nation works on. And so while we front the money for these cases, the victim is paying for it, but we work on this contingency fee structure because most plaintiffs would otherwise not be able to afford representation. It's very, very expensive. And I guess, to put it in perspective, I mean, we don't, as plaintiffs attorneys representing victims and survivors, we don't bill by the hour. We don't do that. But defense attorneys who work for insurance companies, they do. In the life of the case, this just sheds a little bit of perspective on how much their time could be worth. But it's hundreds of thousands of dollars, if not millions of dollars, if they litigate a case for multiple years and take it to trial. And so that just shows you the burden upon a party to a lawsuit and bringing this expense. And so, just to sum that issue up, while a victim may not bear the cost initially, they do pay it on the back end when there's a recovery. And so they're bearing the expense. Re-victimization, I mean, Ryan and I talk about this all the time. We lean on our trauma-informed training heavily when we weigh this. And we've gotten to the point, where I think we've grown more confident in our recommendations because we've seen it play out. But even if there's a small chance that we could do something for a victim, I mean, we are balancing that with whether or not is this really in their best interest. If there's a 1% chance of recovery, that's not good. And we listen to them, how they're doing, and what is a civil lawsuit going to do to them? And it is hard. It is so hard on our clients. It's hard on our staff. It's hard on us, but it's even more difficult on our clients. And we need to be able to evaluate their current state to determine whether or not it is worth it to go through this. So that's the number one for me is re-victimization.
And the reason I asked, and nobody has seen a deposition, and the reason I asked that was that that could be one of the most traumatic things that a victim has to go through, and they will go through it. And I will just say, if you've not seen one, imagine the most brutal cross-examination you've ever seen, without guardrails and without a judge to weigh in. An attorney will do everything they can to defend, but oftentimes defense attorneys can ask just about anything and get away with it.
Yep. Yep. Totally agree. And then you talk about the length of the lawsuits. 2 years, that's probably average from the date that we're retained to resolution. Hopefully it's a successful resolution. That's hard. It just is really on us to manage expectations from day one and let them know that this is a marathon, and that you hear the old adage, the wheels of justice turn slowly. They do. And find a firm. And when you're vetting a firm and you're talking to your clients, tell them to find a firm who you can trust when they tell you that they will push your case as hard as possible.
Mm-hmm.
And that means once the moment that you retain them, they're on it. They're sending opening letters. They're sending demands. If they file a lawsuit, they're immediately getting in front of the judge and asking for a scheduling order and a trial date, because that's ultimately getting a trial date is the only thing that's going to guarantee that your case gets resolved in a timely fashion.
And
that's an important piece for victims to know in their first conversation.
because victims do not have a right to a speedy trial. There's no such thing in the civil system. All right, this is the important part, what everybody can take home, and we're going to cover this in 4 minutes, so we leave 5 minutes open for questions. It's going to be great. Considerations for advocates. You all have what's known as absolute privilege when you assist victims. However, you really need to be careful about whether you're considered officially a victim advocate. That definition is heavily, heavily, heavily dependent for the organization you work for. The reason that matters is because if somebody comes to you and says that they know certain things or certain things happened, a defense attorney can subpoena your notes. So just be very aware, your employer should have policies in place regarding privilege laws. And so it all comes down to whether or not you take notes in the meetings and in your appointments. So make sure you're checking with your employer, and that you know what the law is and what you are considered. And always be careful discussing civil lawsuits until you've sought legal advice regarding what can be discovered. And then never, 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 never give victims legal advice. That is for us to do. Do not give them guarantees. The best thing you can do is say, hey, you can consider this. Let me help you find an attorney. And that's where we get to what we've been talking about this whole time, the importance of finding the right attorney. And Brian and Reed, I'm going to let you explain in 2 minutes what being trauma-informed means to you.
Go ahead, Reed. Talk about Moxa and your relationship with them and what they've done for us.
Yeah, we have these centers are all over the place, and there's a great one literally right next to our office in Springfield. But one of the ones that we lean on and partner with daily is the Missouri Organization to Counter Sexual Assault. They're located in Kansas City. I'm sure a lot of the people attending today have heard of them. They serve the surrounding 6 counties, 4 in Missouri and 2 in Kansas. And they're on the front lines, like a lot of people watching this today. And we are so grateful for their work. We give back as much as we can to them. We have so much respect for the folks that are assisting victims when they make the phone call from the hospital going through their SANE exam, or they need a protective order, or they need just someone to basically hold their hand when they go down to file a police report. And this is the same organization that typically comes in with our team annually and provide to us guidance on how we can better communicate with victims and survivors, listen, and ultimately be at our very best to represent them from day one through a trial if needed.
Yeah, the training we get through Moxa is so important. I mean, they'll sit with us and do mock phone calls with a potential client and help us think of ways to, be more trauma informed and better hear them and better, express the fact that we are listening to them and we believe them. And they've just been a great resource to us in communication.
The last thing that I'll add, and I'm not sure I understood this at the beginning, but one of my biggest takeaways from trauma-informed training is that the best form of trauma-informed communication is being blunt. And it's hard. There's certainly a way in which to deliver news, and a lot of times it's news that a victim or survivor may not want to hear. It may be that we can't take their case or for whatever reason, but that's one of the things that trauma-informed training has taught us and taught me the most.
Again, I want to give everyone time for questions, and we are going to email everyone the slides. We are also, once again, going to be sending you this recording. So with that, are there any questions that we could answer? I'll give everyone a few seconds to type. Well, I explain that we will also be sending contact information for both Reed and Ryan and their firm information with the email that we will be sending. So keep your eye out for that. And if you ever need anything, you can contact us at victimbar.org as well. That is where the attorney referral service form is. But again, if you are in Missouri, I would absolutely contact Reed or Ryan first.
Thank you, Renee, for putting this on, for helping us through it. We really appreciate what you do.
Absolutely. I'm not seeing any questions. I'm seeing a lot of positive feedback in the chat, but no questions. So I think with that, we can let everybody go.
Awesome. Yeah, if you guys do have questions that you think of after this goes away or we get off of this, please feel free to call Reed or I or email us. We're happy to answer any questions you guys have.
Yeah. The other thing I would say is I forgot about this, but we have, so this book we put together about 3 years ago, and there's an e-copy available on our website, but this was a book that was dedicated towards answering a lot of the questions that our clients asked that we talked through today. And if this may be a good resource for victims and survivors that you encounter in Missouri or Kansas, or you're welcome to reach out to us. But again, there's an e-copy on our website that you can pull this from, or if you shoot us an email, we can send you some copies of it.
Do you all want to read off your emails very quickly? Because we did not provide those yet, but
Yeah,
I did
I'll put
just
them in the
put your
chat.
firm in the chat.
I'll put them in the chat.
Okay. Yeah.
Perfect.
It's rfrazier@monsiesmayor.com and rmartins@monsiesmayor.com, but Reed will throw it in the chat.
Yep.
And we'll give everyone a minute to copy those down.
I think there's a question of how can we get physical copies. I think, or you might be talking about the book that Reed just mentioned.
Yeah, just shoot us an email. We'll send it to you.
Yeah, we'll be happy to send it to you. If you shoot us your address, we can send you copies.
All right. Thank you, gentlemen. And thanks everyone for joining us.
Thank you, everyone.
Thank you.
Bye.